This is in the matter of people of the state of Michigan versus Nicholas Ryan Williams. File number 23-21628FH. I have Elias Mawad appearing on behalf of Mr. Williams. I have Isaac Sneed appearing on behalf of the people. Mr. Williams is also appearing, well, he was. So Mr. Williams yesterday at a hearing and also today, oh, there he is. There you go. Is appearing via Zoom. All right. So let me get the pre-sentence report. All right.
Hello, man.
So, okay, Mr. Williams, can you hear me?
Yes, ma'am.
All right. So, Mr. Williams, you received a copy of the pre-sentence report.
I believe so, Your Honor.
Okay, so I need a yes or no. Did you see a report that recommended what your sentence would be in this case? Did you review that with Mr. Mawad?
2 years non-reporting probation. Yes, Your Honor.
Okay, so you got the report. Is that a yes?
Yes.
Okay, and you reviewed that with your attorney, yes?
Yes.
Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, Mr. Mawad, well, first, Mr. Sneed, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, thank you.
Mr. Mawad, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
All right. Mr. Mawad, does the pre-sentence report, well, I don't show any prior record. Is that correct?
Correct. There are 2 misdemeanors, so the guidelines would not apply, Judge.
Yeah. Okay. All right. Mr. Sneed, is there anything you want to say on behalf of the people, or do we have anybody who wishes to speak today? The court will acknowledge that I received a letter from Cameron Williams, or a victim impact statement from Cameron Williams, and does she wish to speak today?
Yes, she does.
All right. So Ms. Williams, you can bring someone up with you if you want someone to stand next to you. Okay. I got to come up to the podium, and then I need you to state, yep, there's some Kleenex. So first I need you to state your full name for the record, okay?
Cameron Williams.
All right, now I'm going to need you to speak up a little bit because we have to record this, okay?
Yes.
All right, you may proceed.
Your Honor, my name is Cameron Williams. I'm here today to tell you about the lasting effects.
It's okay. Why don't you pause for a minute, take a deep breath. And I'm gonna let someone come stand with you. I think a family member's coming up to stand with you, okay? Or a friend, or whoever she is.
My twin sister.
Oh, okay, now I see that. Okay, thank you.
Of the sexual, mental, emotional, and physical abuse that was inflicted on me for years at the hands of my now ex-husband, Nick Williams. His actions towards me have changed my life forever, and I hope today that I'm finally heard. To Nick, I want you to know what your actions have done to me. The pain, the fear, the confusion, and the anxiety that I now have to live with every day, all that I have endured because of you, it has changed my life, everything about it. When I married you, I never imagined having to stand in front of a courtroom and speak about the way that you have tortured, assaulted, harassed, isolated, and affected my life in every way. I'm standing here today because no matter what you have done and continue to do to me, I will not let you have the power to break me, not anymore. During my life with Nick, I lived on constant eggshells. I never knew what each day would bring. I never knew which side of Nick I would be faced with. Would it be the love bombing, the gaslighting? Would it be caring or plain cruel? To me, it took years to even realize the moments Nick showed that he cared was all for an ulterior purpose. My days were filled with sexual coercion, harassment, and threats. Nick worked from home so that he could watch my every move and dictate every single thing that I did. Nick would deprive me of my sleep, take away my ability to even clean my own body. He would isolate me. I wasn't allowed to have real friendships. I could hardly even attend family events without there being punishment or being forced to have sex. It was a never-ending cycle with Nick. It was a constant roller coaster of emotions. Every decision that I made was the wrong one. I wasn't able to make even the smallest decision without Nick criticizing or belittling me. If I did anything outside our home, Nick would make me pay for it with my body. If I wanted to take my kids to a birthday party, if I attended a family event, or heaven forbid I wanted to see friends, Nick would force me to have sex as payment. Sex was all that I had to offer him. I didn't work, I couldn't provide anything financially, and Nick made it clear throughout our marriage that all he cared about was sex and money. It didn't matter how much I did for him, how much I did for our children, how much I loved them, how much I cared for them, or how hard I worked as a homemaker. It was never enough. Nick was cruel in ways that I could never have imagined. Once we became husband and wife, everything he vowed to me went out the door. I was no longer a person. I was his property to control, manipulate, and do as he pleased. My wants, needs, feelings no longer mattered. Nick proved this day after day with his constant harassment. He did not care how he hurt me. He did not care to see me cry. He did not care when I called out involved while he forced himself on me. No short of 100 times. There was no conscience behind his eyes. There was many times I had to leave during the night with our children because of his relentless efforts, all because I said no. He would hit the walls, the ceilings all night long to keep me from falling asleep. If the door would lock, he would break the doorknob. He would figure out a way to get in. He would always find a way. If I did fall asleep, he would wake me up by spitting in my face. He's attacked me in front of the children. They too have suffered issues with sleep and feeling a need to protect me because of the abuse that they have witnessed. He would make me go for days on end without showering, just to make me feel as disgusting as he said I was. He would reprimand me for even changing my underwear. When I took the kids to school, he timed me. If I wasn't home at the exact time I should be, he'd be calling or texting. At one point, he even called to tell me that one of my children was injured and needed to go to a hospital. When I got home, our son was perfectly fine. This was all as a punishment for being late and for saying no to sex. His need to control every aspect of my life was suffocating. Nick never hesitated to punish and take away anything that he could to get his way. He would take away my cell phone, my internet, TV, my journals. There were no boundaries, only a means to an end, and the end would be me having to let him use my body. Through the tears, I proved I was nothing, and even when he used me, it only gave me a few days of peace before the cycle of abuse would start all over again. I tried leaving Nick in 2018. After a domestic assault, I filed for divorce. I was finally going to have the strength to leave. Nick sought counseling, even fooled his parents, who he was then living with, into believing that he was changing. I dropped the charges. I dropped the divorce. I gave him another chance because I just wanted to have a happy family. And since then, he's made me regret that decision every single day. As soon as we were back together, he went back to binge drinking. He quit therapy and once again was forcing me to have sex with him. When I filed in 2018, I thought that was as bad as it could get. But over the next 4 years, he proved that I was wrong. It can always get worse, and my life became a punishment once again. I'd love to stand here before you today and say that Nick has changed, that he has worked on himself to become a better person, but I can't. Nick has not changed. Nick is exactly the same as he has been the last decade. He has never been held accountable for any of his actions. So why would he need to change? Why does he need to be a better person if there is no repercussion for being who he is? Nick has proved he is incapable of change. As I stand here before you, he is constantly trying to find out what I'm doing, who I talk to, where I'm at. He's interrogating our children, mutual friends, anyone that he can. I still feel that he is following me. He knows things that he shouldn't. I see him places that I shouldn't. He makes comments about knowing my whereabouts and when I have gone places. It's constantly leaving me questioning and scared. Nick continues to try to control anything and everything that he can. He does not care about the harmful effects it has on me, our children, or anyone else. Nick only cares about himself. Because of Nick's actions, I still carry the physical and emotional evidence with me every day. I have been in therapy for going on 3 years just to try to learn how to cope with the trauma. I still suffer from insomnia, chronic pain, constant headaches, inability to focus, extreme stress and anxiety. There are days that it's debilitating. Nick's abuse has made even the simplest of tasks feel impossible and overwhelming. I feel like day by day I'm waking up only to survive. I'm unable to enjoy the things I once loved. I feel drained, my energy is gone. I have a hard time trusting people. It affects my relationships with others. There are still days that I cannot even stand to be touched. But I have to push through to provide for our and be there for our children, to provide a better life. I am currently the sole provider for our children. After being a stay-at-home mom for 10 years, I had no other choice but to get a full-time job while Nick was allowed to drain our finances, stop paying health insurance and all the bills. I've had to pick up the slack even when there are court orders to protect us from happening. I'm trying to provide the life that was promised to our children, but when they came into this world, no matter how hard it is, and all while I'm constantly looking over my shoulder. I'm still fearful of what each day may bring. But now that I will also have to fear what's to come from even standing here today, voicing how this has all impacted me. I do not feel that justice is served in this court. I do not feel Nick has learned anything from the sentencing. I think Nick will continue to feel that he can get away with anything because he has proved to himself that he can. Nick's tether was removed and no one told me. I found out from my 8-year-old son. His words were, "Dad's tracker's off. He said now he can do whatever he wants." Knowing that this statement would find its way back to me because he put it out there for it to. There has been unfortunately countless show causes, motions, ex partes filed because of Nick's lack of ability to follow court order and he shows continued lack of respect for any type of authority. I'm sorry to have lost hope and faith in this court system. I do not feel the sentencing will lead to anything other than more pain and fear for the years to come. I do not like considering myself a victim. That means giving Nick even more power over my life. However, in this case, I'm not only a victim of Nick Williams, but I'm a victim of Lenawee County. I will carry the weight of what Nick's done to me for the rest of my life. What I've said today does not even scratch the surface of what he has put me through. However, I respect your time. I know you don't want to be here all day or even multiple days, quite possibly even weeks, if I were to continue on with the full graphic extent of the abuse that I have suffered. I'm also not ready to relive the trauma, and I will be trying to heal from every day of my life. I hope today you see me and hear me as a real person, not as a court document or a piece of paper.
I'm so sorry.
I'm simply asking for justice and for Nick to be held accountable for the torture and anguish that he's put me through. I pray that someday I will be able to heal and find peace. Nick has already taken so much from me, and I just want to rebuild what's left from the scraps he left. But I cannot do that if I have to continue living on edge and fear every day of my life. Thank you.
Welcome. Anything you'd like to say, Mr. Sneed?
I have nothing additional. Thank you.
All right. Mr. Mawad, is there anything you want to say on behalf of your client?
Yeah, first I want to tell Cameron, thank you for giving her our feelings. I think that's good when a victim is able to give out and talk about certain things. This is what I know, Judge. When I've been involved in this case for a long time. I've read a lot of the stuff that's occurred in the domestic, the divorce. Every time I've read something in the domestic case, it's been nothing but complimentary of Nick. He finished his therapy. He's doing well. Cameron said in a deposition, he's a good father. I read the deposition in the domestic case. I don't know anything about past the criminal matter in their relationship. They're divorced. They should be divorced. They both have to work on the kids and to continue making sure that these kids are raised correctly. I know that Nick's a good dad. No one's ever said that. I just wished both of them a great future. I think Nick would like to talk. I've talked to him already about some of this stuff. He does have his ex-wife's feelings, but I hope that she does heal up and she moves on. But I hope that my complete wishes are for the new year that they both do very well in raising these beautiful kids of theirs, and I think they can do it.
All right, Mr. Mawad, who did he complete counseling with?
Judge, can I ask Mr. Nick, who did you do all the counseling with for the domestic case? Sorry, Judge.
McCullough Vargas.
McCullough Vargas, you said?
Yes.
Did you do any counseling with Sally Welch?
No, Brene Moore.
Okay, thank you. All right. All right, Mr. Williams, is there anything you'd like to say on your own behalf?
At this point, Your Honor, I'd like to stand with my lawyer's comments. I'd like to move forward from this divorce. I took a very significant loss in our finances to make sure that that happened during mediation so that we could move forward with the divorce. I've had my kids 50-50 for several months. They're thriving. They're doing well. I look forward to co-parenting and doing things that are in the best interest of our children moving forward. That's all, Your Honor. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record of this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. So, Mr. Williams, there was a plea agreement that was struck between the prosecutor's office and your attorney that stated that you would enter the plea and that your 1-year jail term would be suspended. You would be placed on probation for 2 years, non-reporting, and that your tether would be removed on the date the plea is accepted, and you would be not required to register as a sex offender registration, and the other charges would be dismissed. That Killebrew plea was entered with this court. Mr. Williams, I have watched you through both your divorce case and also this criminal case. And the one thing that is constant is, well, one, that you follow Mr. Mawad's direction, but two, your lack of remorse, empathy, or even emotion about any of this, and your continued toying with her and trying to control her throughout the divorce case. So, and the divorce is final, right? The divorce is final, but yet you still are not in compliance with that. And that to me just signals a continued desire to control the situation. I don't foresee you guys ever being able to co-parent because, you know, I just don't see that as a possibility. But, you know, maybe with help, you will reach a better place in your life. So it's a sentence of the court that you will be placed on probation for a period of 2 years. During that term of probation, you will honor the no contact with Ms. Williams. And so Ms. Williams made some statements regarding things that could be a violation of the PPO. And if there are violations of the PPO, she needs to file that with a show cause with the court. And then also that could result in a violation of your probation. I'm also going to order that you enter in complete domestic violence counseling with Sally Welch. Your probation officer will get you the information on that. That's a long-term program for domestic violence. There is, based on the plea agreement, a non-reporting probation, but you must enter and complete that program with Sally Welch and provide that to the probation officer. I'm going to order $750 in court costs. Misdemeanor fees. There is, because they're misdemeanors, it would be $75 crime victim rights fee. There is $50 in state costs for each count. So that'd be $100 state costs. Is that right, Ms. Fay?
Yes.
Okay. And then on the aggravated assault, there is a $200 fine. And on the stalking charge, that also is a $200 fine. So a total of $400 in fines. Mr. Williams, again, no contact with the victim, Cameron Williams, in this case, not to engage in any assaultive and threatening behavior, and you are to sign any release of information requested by the probation department. But anytime they have cause to believe you violated the terms of your probation, they can access your computer, your phone, your car, and your home, and to determine if there is a violation. You're not to use any illegal controlled substances or commit any criminal offenses. So, Mr. William, is there anything else, Mr. Singh?
No.
Else? All right, so Mr. Williams,
Judge?
you will need, yes,
I
sir.
apologize. I think there's a carve out for, and we're gonna deal with this next year in the PPO violation, but there's a carve out for visiting or talking on the domestic relations, the computer, the emails system, if I
Yeah,
remember.
by
that.
app close, so
Yep.
they'll be able to continue, but remember, that is regarding the children only and must be respectful and appropriate, so we'll allow for that. So Mr. Williams, well, obviously not this week, but next Thursday morning, I need you to report to the district court probation department between 8 and 10. They're gonna have you sign your terms of probation. You can get the information on Ms. Welch to enroll in that domestic violence counseling. And then they'll give you instructions on how to proceed from there. Because of the nature of the charges, there will not be, he has to stay on probation for the maximum of 24 months, so we can't shorten that term of probation. Mr. Williams, we are going to mail to you 3 copies of your notice of right to appellate review. There's going to be a self-addressed stamped envelope as well. And on the first page, I'll have where you can initial and date it, fold that up, put it in the envelope and mail it back to us so we know that you received it. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Anything else, Mr. Sneed?
No, thank you.
Mr. Mawad?
No, thank you, Judge.
Thank you all.
All right, thank you very much. Nick, I'll talk to you in a little bit, okay?
Okay.
Ma'am, when you appear from the press, ma'am, when you appear from the press, you just let my bailiff know you can actually sit over there.
Oh, thank you.
Okay. Thank you. All right. Okay, so, I believe I have the jail. Mr. Murphy, I believe I have your client. So,
I'm gonna ask for a break.
are you Archie Proffitt?
Yes, I am, Your Honor.
Good morning.
Good morning.
It's yours, right?
Yeah, I was gonna ask for a breakout.
Yeah, so I'm gonna call it and then my bailiff will let you in back. So this is in the matter of the people of the state of Michigan versus Archie Proffitt. And this is, hold on, file number 24-21950FH. Matthew Murphy appearing on behalf of Mr. Proffitt, and I have Isaac Sneed appearing on behalf of the people. So Mr. Proffitt, my bailiff's gonna let Mr. Murphy into the back, and then we will open up a breakout room for you two to talk.
Thank you, Your Honor.
Thank you, Your Honor.
Sorry about my ringtone, that's for search warrants, and it isn't muted like the rest of mine are, so I know when the police call, and so we're not, sorry about that. You can come up with it. Come on up. All right, so Mr. Hamden and Mr. Myers, do you guys want to go talk in the back for a little while, or you good?
I think we're good.
Okay, it'll just be a couple minutes. All right, good morning. So, Ms. Underwood, let me grab the file. Just throw all those files away. Okay. So, let's see if this. All right, so, Mr. Sullivan, why don't you go stand with your attorney? So this is in the matter of the people of the state of Michigan versus Deontay Martez Sullivan, file number 19-19746FH. So, Mr. Sullivan, good morning. I hope your drive was okay, because I know you drove a little bit to get here.
Yeah.
Yeah, okay.
Thank you.
Your Honor, you will appreciate that a mother's work is never done. We will thank Mr. Sullivan's mother for.
Yeah.
Well,
Mom.
well, you have a good mom. All right, so Mr. Sullivan, Ms. Underwood, you received a copy of the probation violation report.
We did, and I reviewed it with Mr. Sullivan, Your Honor.
All right, so Mr. Sullivan, you reviewed the pre-sentence or the probation violation report.
Yes, I have.
All right, and you talked about with Ms. Underwood?
Yes.
Do you have any more questions for Ms. Underwood?
No.
Do you have any questions or corrections for anything in this report, Ms. Underwood?
No, we do not.
All right, so you're on probation now in Macomb County, right?
Yes, correct.
Ms. Underwood, is there anything you want to say on behalf of your client?
Just briefly, Your Honor, my client is here today. He understands that he has to complete these items. He's going to be making a $400 payment today, Your Honor, as part of his bonding costs. And
Do you
I would-
have that on you now?
Excuse me?
You have $400 on you now
Yes.
in cash?
No, on my credit card.
Do we take credit cards?
They do now,
Oh, we do?
as long as you have your ID, yeah.
You got your ID?
Yes.
Why don't you go pay that and come back?
Okay.
All right.
So I go downstairs to pay.
Hmm. No, you go down to the end of the hall and pay that.
Okay.
Do you want to show them? Is that all you had? Might help them with that. All right, oh, Mr. Murphy, I'm gonna let in, I'm gonna let, and then I'm gonna put Mr. Proffitt, you and Mr. Murphy. I'll change your screen name so I don't lose you. All right, so I'm gonna put you and Mr. Murphy into a breakout room. So Mr. Proffitt, go ahead and click on join. I don't have anybody else from the jail. If there's anybody in any of the jail rooms that I don't have video on, you could start your video. So.
Approach on Mr. Rogers, is that right?
Sure. Who's we?
Mr. Stevens.
Oh.
Yeah, but I think when we did it, we thought his guidelines were more. Test design reader. Under our sense agreement, like 12 months. So.
We could adjourn. Yeah, we could address it.
Yeah, I talked to Mr. Rogers yesterday about possibility of adjourning it to.
What was the agreement for?
48 months.
There's other charges and cases. And so the guidelines are much higher than the charges. And there would be a case that is being dismissed as part of. So that was the factor in the sentencing.
Yeah, that's.
Well, there's like, there's other ones that like 36 or something. 34 maybe. But we could,
Wait, I don't have the declared possession.
but yeah, I think we need
The
to.
pre-sentencing has possession of. If like other ones.
Yeah, there was some case. Larceny, I think.
Not in the PSI.
It's a 9. You got mine.
And might would be filed.
No,
with
I-
Beaver. Is there
Anyway,
another
we-
PSI? Mine just shows, I'm not contagious, I'm not antibiotics. but-
Oh, yeah. No, this is not, no, Scott Rogers.
Oh, no wonder. That makes more sense. Okay. So, the ones,
Yeah, it seems like it's common. My experience that the guidelines is calculated as applied to. Because the sentence agreement is based on.
so it's easier for me to name them, like it's easier for me to sentence under than over. Like, I got 10 to 34. I got 2 to 25 and 12 to 36. What if I gave them 36 months?
Well, I think Mr. Steve may have probably.
That's what I'm saying.
We still came down to 48, so.
Okay, so we want to adjourn this for you guys to review
Yeah.
guidelines and you do a sentencing memorandum?
Yeah.
Okay. Mr. Rogers, how are you today?
I'm good.
All right, I'm gonna call your case. Okay, this is in the matter of the people of the state of Michigan versus Scott Allen Rogers. We have 4 files, 24-21764FH, 24- we have 3 files, 2 files, I guess I'm actually sentencing on. And then 24-21815FH, there's 4 counts that he pled to. I have Salvatore Malaro appearing on behalf of Mr. Rogers, and I have Isaac Sneed appearing on behalf of the people. So I did have a sidebar with counsel to discuss the guidelines in this matter being different than what the parties, and there are some concerns about the guidelines being accurate. So Mr. Malaro, you are asking for a brief adjournment to review those guidelines?
Yes, sure. I met with Mr. Rogers yesterday, and because of the disparity from what we had originally calculated to what has been scored in the PSI, I would ask to adjourn this so we could review that and either make a proper adjustment or see if we're correct all along.
All right, so Ms. Adams, I'm not sure what sentencing date I might have out, a couple weeks or a week or 2.
Is there something that you guys scored, Sam, that I did not in order to come up with that?
Sarah, Ms.
48 months?
Ms. Teskey, thank you. I'll talk to you later. We'll talk to you later about this.
Oh, okay. There's more to it. Okay.
Okay, all right. So I think Ms. Teskey is gonna fight you guys on her guidelines there for a minute. But okay, so Ms. Adams, do I have a date available in the next month or next week or 2?
We could do January 3rd at 8:15.
Then,
I'm not.
okay, how about the next week?
January 10th at 8:15.
Yeah, I'm gone, man.
Okay, Mr. Sneeds or Mr. Malaro is now gone
I don't come back till 16.
and he doesn't come back to the 16th.
Okay.
Are you here the 16th?
No,
All right, so but he's not here the 16th. So he comes back the 17th.
I come back to work on the 17th, yes.
Yeah, we could do the 17th.
17th?
Yeah, that's fine.
All right, so Mr. Rogers, I'm gonna adjourn this to January 17 at 8:15 in the morning. And Mr. Rogers, I'm also gonna order a sentencing memorandum just so that I know in advance and can prepare for what's gonna happen that day. And provide a copy of that to Ms. Teskey as well. And is there anything else we need to address?
No, Your Honor.
No, thank you.
All right, hold on, Ms. Teskey. All right, okay, so. Okay, Mr. Rogers, you're all set. Thank you.
Okay.
Mr. Sullivan back?
May I address something that's scheduled this afternoon? I have a 1:15 competency hearing with you. May I connect by Zoom? Okay,
Yeah, that's fine.
all right, thank you.
Thank you. Okay, so, Rogers.
Good morning.
All right, thank you. Merry Christmas, everybody.
Merry Christmas, Joe.
All right, I got Mr. Proffitt back. So Mr. Murphy, you ready on Mr. Proffitt?
Yes, Your Honor.
All right. Okay, you're back on the record in the matter of the people of the state of Michigan versus Archie Noah Proffitt. Mr. Murphy, you received a copy of the pre-sentence report?
Yes, Your Honor.
And Mr. Proffitt, did you get to review that pre-sentence report with your attorney?
Yes, Your Honor.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, Your Honor.
All right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in that pre-sentence report?
No, Your Honor, not the accuracy or relevancy.
Okay, the probation department has computed the minimum sentencing guidelines to be 5 to 23 months. Do you dispute the guidelines?
I do not dispute the ultimate computation of those guidelines, Your Honor.
Okay, and before the court passes sentence, is there anything you'd like to say on behalf of Mr. Proffitt?
Yes, Your Honor. If the court recalls, when Mr. Proffitt entered this plea, we had expressed that, from the very beginning down in district court, when we waived the examination, there were discussions about his sentence and it being as one concurrent or whatever, we can work out with the pending MDOC parole violation that he had going on. Now, in regards to this matter, when we entered the plea, we had discussed, again, I think we placed on the record that the agreement by the prosecution was that it would run concurrent with the MDOC violation. And obviously there's some issue, I believe was expressed by the probation department that may not be allowable. Because of such, would ask the court to consider, now I understand the recommendation is for 1 year in jail, and I understand that there's no credit because he's been on a parole hold, but he has been in custody for quite a while now, ultimately from these charges, waiting for, I understand the situation. I'd ask the court to consider though, taking into consideration the time that he has been in jail from the incident that's occurring, the fact that it was intention, it was our intention to have this run concurrent with the pending MDOC parole violation, whatever that ultimately would be. I'd ask the court to consider, I would say credit for time served, but there's no time served because of the situation. But I think that, honestly, Your Honor, look at this, it's a matter of sentencing him to jail is a matter of punishment. There's no rehabilitation that's going on there. There's no real purpose for it other than that, to punish Mr. Proffitt, to an extent, and allow him to go on to with his life, with the rest of his rehabilitation. So the length of time that he spends in jail, again, it's just about punishing him. And I think he's already been in time for long enough. He has a pending parole violation. I'd ask the court again to consider credit for time served, even though it's 1 day or 0 or 1 day, process him for 1 more day and let whatever. That's I ask the court to consider again, is Mr. Proffitt's understanding, and it was just my hope that it would be something that it wouldn't delay ultimately the MDOC violation, for a year or anything like that. And it is understanding that everything would be concurrent, meaning that there wouldn't be sentences going after one another. So again, that's what I ask the court to consider. Credit for time served of 0 days or maybe just 1 day processing that.
He's on parole for the possession of cocaine out of Jackson County, right?
Is that what you're on parole for, Mr.
Yes, Your
Proffitt?
Honor. Yes, Your Honor.
And that's 4-year max. So he's 3 years in on that. Right, okay. All right, anything you want to say on your own behalf, Mr. Proffitt?
No, Your Honor, just that, that we had the agreement of running it concurrent with what I'm currently doing on parole now. The last court session we had, Your Honor, Joanne Holly spoke up and said to you that you can't do that, Your Honor, and you had said, even if you got to get crafty with your sentencing, that's what was going to happen. Was the reason I took that plea, Your Honor. That's all. I'm just.
If I may add some more, Your Honor, and speaking to Mr. Proffitt, again, I don't believe that there's a necessity for it because the rehabilitation part's going to be achieved. The punishment is what this is talking about. And that's why, again, I'm focusing on, I don't think there's any necessity for further incarceration to punish him. I think he's in a mindset to be rehabilitated moving forward with that parole violation.
Ms. Holly, the nature of this offense, they're probably just gonna parole violation, gonna give him credit for what he served, right?
Yeah, they're probably gonna defer to court. I know his parole was extended.
Right, but they can't extend it more than 4 years, so he's already
Right.
3 years in.
I guess the update now is May 29, 25.
Okay.
But yeah, they'll probably defer to whatever you guys do. I'm guessing it won't take more time.
Anything else?
Nothing further, Your Honor. Thank you.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential reformation, vindication for the law and protection of society. It's sent to the court. You'll serve 6 months in Lenawee County Jail. You'll get no credit. He'll probably be released from his parole violation, and any credit he served will be applied to that. So I've deducted that.
Yes, Your Honor.
So, Mr. Proffitt, I'm not gonna place you on probation because you're already on parole. So you have to pay $130 crime victim rights fee and $68 in state costs. Now, you do have the right to appeal this sentence, Mr. Proffitt. We're gonna send over to you 3 copies of your notice of right to appellate review. You're gonna initial and date 1 copy just for our records to acknowledge you received it, and the other copies are for you. Mr. Proffitt, I hope that through your continued parole that you get into some substance abuse treatment, because this is kind of just a vicious cycle you're stuck in right now. All right? All right. Good luck to you, Mr. Proffitt.
Thank you, Mr. Proffitt. You have a good day.
So I will be serving 6 more months from today's date.
Yeah. Not the year that was recommended, just 6 months, because you've been in 4 months, and then there's good time. So I took count of that.
Also, I'll get credit for the time that I've served.
You don't, but you do. As you said, I got crafty.
All right, thank you, Your Honor.
Thank you.
Honor, is Ms. Whitman, is she participating? Is she?
She's not here yet.
Well, what if they tried
Okay.
and she?
So Mr. Sullivan, you want to come back up?
Thank you, Judge.
Thank you, Ms. Holly. Merry Christmas.
You too.
Okay, so now we are back with Mr. Sullivan. Mr. Sullivan, you paid the 400?
He did.
All right, so Mr. Sullivan, you read through the pre-sentence report? You read the report with Miss Underwood, right?
Oh, yes,
You're
correct.
satisfied with her as your attorney?
Yes.
All right, is there anything you want to say on behalf of your client?
Your Honor, I see that he has paid half, almost half of the fines and costs that are owed. His discharge date is, I think, I would think termination would be appropriate at this
Okay.
time.
Anything you want to say, Mr. Sullivan?
I just want to say,
Speak up, please. You gotta speak up loudly for me. You're very
Oh.
soft-spoken.
I'm sorry. I just want to say that I apologize for any inconvenience I caused this courtroom. I apologize to my mama for having her having to call off work and have to get me here. And I just want to say that I just want to change. I want to make a change for myself, and that's what I'm headed in that direction right now. I'm in a program called the reentry program. They also help further like my skills and stuff so I can have a career, and that's what I'm working toward.
Okay. So, Mr. Sullivan, sentenced in the court, then I revoke and terminate your probation. You paid your state cause, crime victim rights fee and a little bit on your fine, so I'm fine with that. Mr. Sullivan, so you're not gonna be on probation anymore here, okay? You're done. Thank you for making that payment. You buy your mother a really nice Christmas present,
Oh, yeah, I am.
all right? And you be good to your mother,
Okay.
because, you know, she's here, she's supporting you. You're a nice young man who has done some stupid stuff. But I do believe that that's not who you are. All right, you're working, right?
Yes,
And you told me that before, and you're trying to make these changes, you can do that.
yes,
All right, so do you live with your mom?
no,
Okay, so anyway, nice present for your mom,
okay,
nicer than you buy anybody else, even your girlfriend, all right?
okay.
All right, so I have your advice of rights. I'm gonna have my bailiff hand it down to you. You're gonna initial and date one copy of our records
Okay.
to acknowledge you received the paperwork. The other two are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right? All right, so go ahead and initial and date that.
My initial. Yeah, put your initial there. Take, yes. Oh. I've been doing that at my job, putting the wrong date on my sign. I'll just say, yeah, your hands.
All right, so you are all set. You have a Merry Christmas, all right?
Okay, thank you.
Thank you. Drive safe. I will. Thank you. Record should reflect, bye ma'am. Drive safe. Record should reflect, I received back a signed copy of the notice of right to appellate review. Okay, so, that's
Thank you,
it.
Your Honor.
You're welcome. All right, I have Miss Whitman.
Or court staff before Christmas. Have a great Christmas.
You won't, because
everyone.
I'm gone Monday, so Merry Christmas. All right, Miss Murphy, I have Miss Whitman. So this is in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whitman. File number 21-20579 FH. Matthew Murphy appearing on behalf of Miss Whitman. This is a date and time set for sentencing. Mr. Murphy, we have to put the competency on the record.
Yes, Your Honor.
So I need a prosecutor.
Yeah, I don't.
Miss Spade, this is for you. Oh, thank you, Judge. You're welcome. Let me see if I can get Mr. Sneed back. Seems to be the unlucky soul here today. Is he just sitting next door? Or?
I don't know. Want me to go look?
Yeah.
You have reached Kim Case with the Lenawee County.
No?
No prosecutor.
All right, Ms. Whitman, give me just a moment. I'm gonna go find a prosecutor.
Lincoln's ornament?
I'm sorry, what'd you say?
You said you had Lincoln's ornament?
I don't have it today, but where?
Yeah, that's why I was,
Are you gonna be here Monday?
yeah,
Can you get it Monday?
yeah, I
Okay.
should have, I've been sick all week, I wasn't thinking, but it would have
Oh,
made
I'm
sense, because
sorry.
I'll have him this weekend
Yeah.
for him to put it up.
Wait, you gonna have them this weekend?
I'll have him this weekend, but
You
I
know what?
won't.
I'll run home and get it, cause I think I don't have it wrapped.
No,
yet.
don't worry about it, because I got stuff to do. I don't want, and the roads are bad. I don't want to have something around. But I'll just pick it up Monday and then you'll put it up and we'll take a picture of it.
Okay, okay. And I ordered the plush,
Yeah.
there's two of them, but I don't know.
Yeah.
It's Steve, I think one of them is Steve, and I don't know who the other character is.
I don't know either. That's why it's so funny. Because
Right,
I'm
right.
like, you know, I think back to when I was a kid and you know, your
Yeah.
parents used to land on a text everything. But
Right.
yeah, I don't know any of this.
Oh, and hi.
I could not see that it was you from back there.
Yeah,
So-
I'm up here now. I love it up here.
Yeah, well,
Hey, can you give me a second? Your parents, they're so much. They just really do so much.
oh, yeah. Yeah.
Just ask them to be.
Yeah, Dad calls me up every now and then when he's got a legal question.
Yeah.
So he called me up the other day. Trying to figure out your security deposit back or something like that. So he called me up. So
Yeah, she just needs it.
Okay.
So, thank you. I appreciate it.
you're welcome. And Merry Christmas.
Thank you. Merry Christmas. So when do you get them, or do you have them now?
I get them today.
Do you? Okay,
I'll get them this afternoon.
okay. So do you have to travel?
Yeah, I gotta drive down there.
Gotcha,
Then we'll be going back, taking it back on Sunday.
gotcha,
Then I'll have them again after Christmas.
okay.
But
What time are you leaving? I can go home on my lunch hour.
no, that's okay. Don't worry about going
Sure,
over the
okay.
shower. I got training videos after lunch.
Okay.
So yeah, it was my fault. I should have
Oh, no, that's.
contacted you before that. If
That's
I could pick
okay.
it up
I
today.
should have remembered though. So no problem.
You have a lot of other stuff going on for the holidays. Yeah.
Yeah,
It's so frustrating or stressful trying to plan everything.
it
and read
really,
everything.
it does. It really does.
Is that Joanne Spades that's talking in there?
Yep.
Hello, Mr. Glazier.
Hello, I haven't seen or heard you in a while.
I know, it's been a while.
I'm sitting here with I was going to say lovely wife, but I'm not sure I want to say that.
Oh, I'm sure that's exactly how you should describe her. Exactly.
She's been being mean to me lately, so I don't know if I want to call her that.
And I'm sure that's not even remotely, deserved. Oh, please tell her I said hi.
She's sitting right here.
Hi, Joanne.
Hello,
Did you-
how are you?
I'm
Annette?
in my jammy, so
Oh, okay.
I haven't got dressed for work yet. How are you?
Oh, gotcha. Will you be careful on the roads?
Oh, yeah, thank you. Merry Christmas to you.
Merry Christmas, Annette. Have a great holiday.
Where is she?
You can't see her, but she can see you.
Oh,
Yeah,
Like
I
my
can
hair?
see you.
I'm
Yeah,
doing
Bobby,
my
I
hair.
see- Oh, there you go.
We're both gray hairs now. She's trying to look like
It's- She looks lovely in gray hair.
Actually-
I'm all gray too.
she's trying to look like me, is why she did it.
Oh, gotcha.
Please rise for court's now session. You may be seated.
Mr. Glazier.
Yes.
Joe, let me see if they'll bring Miss Barrett. I asked for her, but. Hey, this is Judge Ann Sloan. I'm ready for Samantha Barrett too.
Are you all finished with?
No, I'm not. You can only do one female at a time, right?
I can, because the other Zoom room is not working at the moment.
Not a problem. All right, thank you.
Yep, bye.
Bye. Who is Joshua Rowy? They found, huh?
Or look it up. I can.
I'm looking it up right now. Mr. Daggermer goes in. He was here earlier, but he had to go somewhere else. No. So. Mr. Murphy, do you want to like have a step back?
Yeah.
Oh, never mind. I got Mr. Steen. I'm sorry, Mr. Steen. We received a competency. Would you like to see it?
Okay, let's see. Yes.
So I'll give you a minute to, oh, here, it's right here. She was found.
People are prepared to proceed.
All right, so this is in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whitman, file number 21-20579FH. Matthew Murphy appearing on behalf of Ms. Whitman, and I have Isaac Sneed appearing on behalf of the people. Thank you, Mr. Sneed, for interrupting what you were doing to come up here. I appreciate that. I think we hunted you down on the first floor or something like that. So this court has received a competency report dated November 13 of 2024. And I don't have my records that it was placed on the record, but
Yes. Yeah. Your Honor, we have received that copy of that. I don't know if the prosecution has or not, but in regards to myself, we have reviewed that. I guess, I mean, I don't have a separate forensic report to provide to the court. I have
mine.
No, I mean, I don't have a separate, another person who have done another, because I would object. I don't believe she is competent to stand trial. But again, I don't have another forensic evaluation to say as much.
You've read, okay.
I've read a few through this. When you look at it, and if the court recalls the experience with Ms. Whitman, she wasn't responding, and that was evident throughout the interview. She wasn't really responding. And because of such, well, I understand their development determination. I believe that it's difficult to assess. I mean, if she's not answering the question, she's not really responding other than yes or no, nodding, or I mean, that's only one or two answers. A lot of times the questions require an answer as far as a copy of the yes or no, a nod or a shake of the head. And besides, that's just, again, a very minimal response, it seems like. In regards to the matter, again, as the court experienced, she wasn't verbally responding to the court when the court tried to continue a sentencing. And that was required. That's required on the record for things to be said, not shaking of a head, not waving of a hands or anything to that effect. But again, I don't.
Do you want to talk to her this morning?
No, Your Honor, because I was asking the court, based upon the email from.
When's the last time you spoke to Ms. Whitman?
A couple of weeks ago, I attempted to, I believe.
Okay. Ms. Whitman, she's saying, Ms. Whitman, can you unmute your device? Okay. No, follow my, oh, okay, she's talking to me now. Okay, so Ms. Whitman, is there something that popped up that says unmute? There you go. Click that button. Okay, so she told me to wait a minute. I guess I'm just asking, do you want to speak with her this morning?
I wanted to continue with from what Ms. Walsh had said with the sentencing. I just wanted to face that issue.
I understand that, but I'm just saying, you haven't spoke with her in a couple of weeks. She's communicating with jail staff right now.
I think I'm fine unless she wanted to speak with me.
Have you reviewed this with her?
No. I haven't.
Okay, so what I would like you to do is review this with her and talk to her about this psychological evaluation, also the email from Ms. Walsh.
Yes, Your Honor.
If you don't mind.
Yes.
I just think we need to review that with her. Okay, so I'm going to, from the jail, all I see is your torso. Hi, I'm gonna make a breakout room and put Mr. Murphy and Ms. Whitman in it. So if you could stay for a minute and help her join that breakout room.
Can you hear me?
I can hear you. Okay, so Ms. Whitman, give us just a minute, and then Mr. Murphy is gonna log on. And I'm gonna put you two in a breakout room, so then I'll send you a request to join the breakout room, and you just use the mouse and click on join when it pops up, but it won't pop up yet, okay? Okay, good. So give us just a moment. He's going in back and logging on right now. And here he is. All right, stop. All right, so I'm going to assign Mr. Murphy and Ms. Whitman, you to this breakout room. So did you get an invitation to join? Go ahead and use the mouse and click on that to join the breakout room. And she's done so. Very good. Do you need to run back?
If I may come back in about 10 minutes, Judge. Sure. I'll do that.
Okay. Okay, and Mr. Glazier, I can only get, they only have access for one woman at a time at the jail, so just be a minute.
That's fine.
There's somebody that didn't show up. Okay. All right, so Mr. Hamden and Mr. Myers, you want to step up? All right, this is in the matter of Justin Gonzalez versus Citizens United Reciprocal Exchange and Reciprocal Management Corporation, file number 23-7227 CK. I have Dominic N. Hamden, P67745, appearing on behalf of the plaintiff, and I have
Scott Musson.
Okay, yes, Scott. Where's your client? That's your
My
client.
client's in the back of the room, Judge.
Okay, where's your client?
I have them available by phone. They're in New Jersey.
I need your last
Come
name.
on.
Last name.
And it's, hold on, let me do it. Scott P. Musson, Mussin, P66748.
Thank you, Judge.
You're welcome. All right, and so I require for settlement conferences, all parties with settlement authority have to be present in person. I don't care where they are. So it's just, it's on the scheduling order. And I do require that because there's really no incentive to try to settle. And I do this as a settlement conference. So sometimes I'm sure to Mr. Hamden's displeasure, I can keep you here an hour or 3, but if I think I can settle a case, I will. So I'm gonna reschedule this, but somebody's gotta be here in person with settlement authority, all right?
I'll make sure they fly out.
Yeah, so anything else, any objections to that? Or-
No, Your Honor, I obviously we came in with the intent to try to get this resolved short. There's the hearing scheduled in January. So we were hoping to get this resolved.
What's
short.
the hearing date in January? 13th?
January 13th. It's defendant's motion for summary disposition. I did ask the court if we could adjourn this until after that because my adjusters are kind of telling me we've got nothing on this until we get that summary heard and determined that way, which is why I asked to adjourn.
So Ms. Adams, I'm looking for a settlement conference date after January 13, so it could be end of January or February even.
We could do January 24 or 31st.
Any preference on a day?
31st for me, remember. 24th, I have a number of depositions.
Say that again.
I'm sorry, the 31st would be a better day for my office. On the 24th, I have a number of depositions.
Is that good for you?
Yes, Judge.
Okay, so January 24.
31st.
January 31st, all right. I can't like hear anything, so. At 9 AM, and this is, I said, again, in person. I'll get copies of this today, and let me fill this out.
I guess I would just ask Judge that we're here today with my client. I would just ask the court to reserve the issue of fees for today. Sure. There's already a reservation on a previous order for some concerns regarding violation of the court's previous order.
I will reserve those.
If I may object to that a little bit, I did call the court yesterday and asked, and the court advised we could stipulate to move this settlement conference. And I called Mr. Hampton's office and asked him if he would.
That's why I reserved it, so we can argue this at a later date.
Okay.
Yeah, no, I'm not granting it.
And I don't want to get into it, Judge, but I got the phone call at 2:30 the day before. So.
Ms. Adams, could I get 3 copies of the scheduling order for council?
Of course.
You did, and I told
All
you.
right, gentlemen, no, just stop. You can do this on your own time. All right, in the matter of Keith Richard.
Thank you, Judge.
Miller, hold on, I'm gonna get you scheduling orders, so stay there. Keith Richard Miller versus Sheila Thompson, file number 24-247305. No one's appeared on that case, so you take that. No. If I can just get 3 copies of the scheduling order, thank you. We'll get you that, and we'll be on your way. So I'm gonna guess that one's settled. Or that one probably settled.
Okay, thank you, Judge.
All right, so, Mr. Murphy's back. Okay, all right, so we're back on the record with Ms. Whitman. No, I just wanted you to review that with her before we proceeded any further.
I do apologize, Your Honor, for not helping on that.
No, I understand it came in. Mr. Sneed had to back to that hearing. He'll be back in like 5 minutes.
Okay.
Is that all right? Okay, so have a seat right there. Council table's fine.
Actually, can I go down to district court real quick?
There's never a real quick. You're gonna be.
I'm not gonna be on the record. I just want to see what's going on and come back down.
Mr. Hammond gets 2 because his client's here. Oh, the other way. Yeah, okay.
Oh.
All right, thank you. Thank you. Drive safe.
Thank you again.
Judge, are those attorneys gone?
Not yet.
Oh,
Why?
well, I was just wondering what was. They're out of the courtroom?
No, but we're live on YouTube.
Oh, okay.
Okay, so I've got Mr. Sneed back, Ms. Whitman. So Mr. Murphy, you reviewed the competency report. Now you're stating, I would like to get it submitted whether you agree to it or not, and you're requesting an independent, that's fine.
Your Honor, we stipulate to the minutes of that competency report. At this point, I have no objection to the court finding Ms. Whitman competent.
All right, Mr. Sneed, do you stipulate to the admission of this report dated November 13 of 24?
Yes, thank you.
All right, so the court has received on November 13 of 2024 competency to stand trial report. Upon review of that, the court finds that to the back of it. One, get back there. Okay, so Dr. Chinwe Eric, MD, that's CHINWEERIKE, MD, Forensic Psychiatry Fellow, Diplomat in Psychiatry and Child and Adolescent Psychiatry in the American Board of Psychiatry and Neurology, and Dr. Alexandra Adu, AUDU, MD, Consulting Forensic Examiner, Diplomat Psychiatry and Forensic Psychiatry, and the American Board of Psychiatry and Neurology. They, in their opinion, Ms. Whitman's lack of verbal communication during the interviews appears to be behavioral and under her volitional control. I acknowledge concern that she may present challenges to choosing not to actively participate in consultations with an attorney or court processes more generally, detracting from her actual functioning in the context of her current circumstances. Nevertheless, in their opinion, choices she may make not to cooperate with supports is not the result of a clinical debilitating mental condition, but rather reflects volitional decisions, perhaps influenced by her personality or character traits. Consequently, while I respectfully acknowledge the ultimate decision in this matter depends on a judicial determination, it is their opinion that Ms. Whitman should be considered competent to stand trial. So I will find that Ms. Whitman is competent to stand trial. And Mr. Sneed, can your office prepare the orders on that, please?
Yes.
All right, thank you so much. All right, so do we need Mr. Sneed any further?
I don't think so, Your Honor, no.
Mr. Sneed, you may go back to your other hearing. Thank you so much.
I'll talk to you later.
So based on that, Mr. Murphy, how do you wish to proceed today?
Your Honor, I would ask the court to continue with sentencing this morning. I think that it's appropriate. I don't want to talk about it, I'm sorry. Because I reviewed with Ms. Whitman previously, the PSI, and then again this morning. There were no issues, additions, or corrections with the information. She doesn't recall the incident itself, but in regards to the matter, Your Honor, I believe that Ms. Walsh had indicated that her recommendation is changed now from probation to credit for time served. Now, if Your Honor, I don't know, I forgot if I've gone to length to this court about this case, but it was involving her ex-husband, and the person during the police investigation eventually admitted, yes, I had a shovel, yes, so the possession of the taser may have been justified, but obviously Ms. Whitman, she deeply regrets the incident. She's going to try to make changes now, be around people like that moving forward. I believe that credit for time served is appropriate. I guess any fines and costs the court would think is appropriate as well, but I would ask the court to consider minimal fines and costs. I don't believe Ms. Whitman right now is really in a spot, considering the time she's been in custody, to really give money forth to the court.
Okay. The guidelines were 0 to 17 months. Do you dispute those guidelines?
We don't dispute those, Your Honor.
All right. So Ms. Whitman, have you had a chance to speak to Mr. Murphy now? Okay, yes. So, yep, and could you step forward a little bit, because when you stand in back, we don't pick up your voice. So you've talked to Mr. Murphy?
Yes.
Are you satisfied with him as your attorney and the advice that he has given you?
Yes, I am.
All right, is there anything you'd like to say on the record before I pass sentence?
No, thank you, Your Honor.
Mr. Murphy, anything else you want to say?
No, Your Honor, just we do apologize for the case panning out the way it did, I guess.
No. Mr. Murphy, never have to apologize. That's our jobs, right? And when we have concerns, we have to address them. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, their history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. Sentence of the court that you will be giving credit for time served. I think we're at like 128 days now, but I'll give credit for time served, whatever it is. I'm not going to place you on probation. I must assess a $68 state cost and $130 crime victim rights fee. So I will assess those. Mr. Moore, do I have to assess a DNA fee on the first time? Do I have to, or no? I don't think so. Yes?
DNA fee, correct.
And there's $60 DNA fee. So Ms. Whitman, we're going to hand over to you. at the jail, 3 copies of your notice of right to appellate review. They're gonna have you initial and date 1 copy for our records, just to acknowledge you received that paperwork, okay? The other 2 copies are for you. You're gonna get out of jail today. The other 2 copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right, Ms. Whitman?
Okay.
All right, Ms.
Yes, ma'am.
Whitman, Merry Christmas, and I hope you the best, wish you the best of luck, okay?
Thank you.
Thank you,
Thank
Ms.
you.
Whitman. You have a good day, okay? Happy holidays. Thank you, Your Honor.
Thank you, Mr. Murphy. All right, will you let them know I need Miss Barrett next?
Yeah.
Thank you. All right, I can call your case. All right. So this is in the matter of the people of the state of Michigan versus Joshua Dexter Rowy. We have 2 files, 24-21911FH, 21957FH. So this is a date time set for sentencing. Mr. Rowy is still missing fingerprints on 24-21957FH. I had asked him to go get those and he didn't go get them. He's not here today. And do you know where he is?
I don't, Your Honor. I tried to contact him throughout this case historically. His phone number has, not really by fault of his own, but his phone number has changed at least 4 times. I've called the numbers I have on record. I haven't contacted him.
Okay, so thank you for that diligence. All right, I am going to issue a bench warrant for failure to appear. He was given notice on the record to appear. He has failed to do so. I'm gonna set bond in the amount of 50,000 cash as surety on each file. Obviously, Mr. Degemer goes in. If you get in contact with him, I'm glad to add this to the docket and get it taken care of. I don't think he appeared for the PSI either, did he?
I did.
Let me see here. I don't. Looks like he showed up.
Yeah, and throughout the case, he has.
Yeah, I mean, historically, he's shown up.
Yeah.
I wonder if he's in jail somewhere. Do you have a way to check
I
that?
checked fine, like I didn't see him in any other county, but it's not like 100% accurate.
Right, right. All right, well, if you hear from him, let us know. All right, Mr. Degemer goes, have a good Christmas. Thank you.
Thank you.
All right, so Miss Barrett, how are you today?
Great, how are you?
I'm good. All right, so this is in the matter of people of the state of Michigan versus Samantha Jo Barrett. We have 1 file, file number 24-21861FH. Ms. Barrett is appearing via the jail, and Mr. Glazier represents her. So, Mr. Glazier, have you had an opportunity to read and review the pre-sentence report with your client?
I have not, Your Honor.
All right, you need a breakout room?
Yes, I do.
Okay. Have a breakout room. All right, so Ms. Barrett, I'm going to assign you and Mr. Glazier to a breakout room. So go ahead and join that breakout room.
All right, thank you.
All right. So our 10 o'clock's via Zoom. I'm gonna do that from my office. And then, a child interview at 1:30 and a review. All right, Mr. Glazier, I will close that breakout room and bring, here she is, Miss Barrett brought herself back. All right, so Miss Barrett, have you had a chance to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to discuss that with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Glazier as your attorney and the advice that he has given you?
Yes, ma'am.
Probation Department has calculated the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines, Mr. Glazier?
Yes, Your Honor.
Mr. Glazier, did you wish to explain or challenge the accuracy or relevancy? I can't remember if I asked you that.
No, I don't, Your Honor.
All right, and Miss Barrett has 4 prior misdemeanors and 2 prior felonies. Do you believe there's any constitutional defect in those prior convictions?
No.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Ms. Barrett?
Your Honor, just, she is an addict. She acknowledges that. She's told me that in the past, she wasn't ready to stay sober and stay off the drugs, but she is of that frame of mind now. She's been in jail 37 days, so she's obviously clean at this point, but she needs a support system around her. I think that can be provided, Your Honor, without an inpatient program, but I guess that's up to the court. She does have 2 young children. I forget, she told me their ages 10 and 8 or something. She has joint custody with her father. She says they have a very good relationship in parenting those children. We'd ask the court to consider releasing her with testing until an appropriate program is found.
Ms. Barrett, is there any? Oh, I'm sorry, Mr.
Yeah, I'm not so sure that this might not be a case that she could probably screen for drug court. That might be an option too.
She was previously in the recovery court program, were you not, Ms. Barrett?
Yes, I was, ma'am. But I can do testing, I know that.
Okay, anything else, Mr. Glazier?
No, Your Honor.
All right, Miss Barrett, is there anything you want to say on your own behalf?
If I'm allowed to, yeah, I would just like to speak and say, as far as she said, I wasn't ready before, like I wasn't ready to stay clean, and I can admit that to myself and other people. But this time something's different in me. Like I want to change, I want to be different, I want to be better, especially for my kids so they don't miss out on me being in their life. That's all, man.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Sent to the court, you'll be placed on probation for a period of 2 years with the Michigan Department of Corrections. During the term of probation, you will obey and comply with all the provisions in your articles of probation. You're not to violate any criminal laws of any unit of government. You can't leave the state of Michigan without the consent of the court. You're not to use or possess alcohol or any other intoxicants. You can't be in any restaurant that turns into a bar at 11 p.m. So where the primary purpose is serving alcohol, so you'd have to leave after the dinner. You must comply with all testing for alcohol and drugs. You're not to use any illegal controlled substances, and that does include marijuana, because, you know, obviously you have an addiction issue. You can use prescription drugs only as prescribed by your licensed physician. Any narcotics you're prescribed, unless it's an emergency situation, must be approved before you fill the prescription by the probation department. You must complete outpatient residential substance abuse treatment when referred. The substance abuse assessment report truthfully every month as required, whether weekly or biweekly. Notify of any change of address or employment status. You have a curfew from 10 p.m. to 6 a.m. unless if you have a work shift that extends into that time period, Ms. Teskey will give you approval for that. You must obey all court orders, not engage in any assaultive, abusive, threatening, or intimidating behavior, not use any object as a weapon. You are to report to your field agent the first business day following placement on probation or release from jail. Comply with any written or verbal orders. Allow supervision in your home so they can enter your home for supervision purposes. Submit to search of your person and property. That could be your phone, your computer, your car, if they have reasonable cause to believe you have items which violate the conditions of your probation. Report any police contact, change of employment, or change of residence within 24 hours. Maintain employment. There is a $130 crime victim right fee, $30 supervision fee per month, or $60 if they need a tether, $750 of court costs, $60, $60 DNA fee if they need to assess it. You might have already been assessed that on a prior file. $68 in the state costs. I'm going to order that you serve 6 months in Lenawee County Jail, but you can be released early to treatment. So as soon as we can find a bed for you, you'll be released to an inpatient treatment program. So ma'am, you can't be an addict and a good mom. And I think you want to be a good, I think you want to be a good mom. I know you love your kids, but until you get that under control, you can't be a good mom. So, you need to work hard on your addiction issues, fix that. And then slowly, once you do that, you will be able to resume being a good mom that you are inside. I know you're a good mom, but kids don't deserve to be exposed to that stuff. Now, you do have the right to appeal the sentence. We're going to provide to you 3 copies of your notice of right to appellate review. 1 copy, they're going to have you initial and date. That'll get returned to me to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out information on the form and mail it to the address listed on the form within 42 days. All right?
All right.
Your Honor, you didn't put credit for time served.
35 days. No, we got more than that.
I just need to know who my PO is.
Sarah Teskey or Jen Walsh.
Agent Walsh.
Okay.
Yeah. Are you in jail on this right now?
Yeah.
Okay, so Mr. Moore, I don't have updated credit on this.
Okay. Let me take a quick look here.
You must have gone back to jail at some point. Do you know when did you go back to jail?
October 24th.
So she's got another 2 months.
Give me a second. 58 days on top.
Okay, so I'll give you credit for the 58 days. All right, so good luck to you, Ms. Barrett.
Your Honor, I had one other thing. Will, the probation department try to get her into a program? Our Emily White is gone on maternity for a while. Is that something you guys can do, Tom?
Say that, well, yeah, usually probation gets on it right away, and as soon as the bed opens, we ship her to a facility.
Yes, we'll
Does it
handle
usually
that.
happen pretty quick? I'm just asking. I'm
Usually
sorry.
within a week or so, usually.
Okay.
Maybe slower because of the holiday, but
Right.
I don't know.
All right.
All right, you're going on maternity leave, Mr. Glazier, is that what you said?
Yeah, I wish. No, the girl Emily White that does the helps us get people in the program.
Okay. We
Okay.
also, Miss Walsh will work on that now too, so. All right.
All right.
Thank you both. Everybody have a good Christmas. Thank you.
All right, Merry Christmas.
Your Honor, the one thing I was asking about those attorneys, that one reminded me.
Hold on, Mr.